Hello, members of Congress. My name is Paul J. Southwick, and I'm from Petaluma, California. I have an enduring family law case that has gone 22 years. My case started in Santa Maria, California in late 1989 when my wife abandoned me and took off with my children. The case went for 7 years in the Santa Maria courts before 4 Superior Court judges, the third one walking off the bench during a 2.5-day custody proceeding. All during that 7 years, I was accused falsely of abuse and neglect, and those allegations have never been resolved. My case was transferred to the Sonoma County courts in 1995 on a venue change 6 years after I filed the petition for separation. My ex-wife was served in another county, the County of Kings in Hanford, and I lived in Santa Maria in Santa Barbara County. I filed originally a separation, and when she responded to the summons, she did not meet the residency requirements that were mandated under state law, that being 6 months residency in the state and 3 months residency in the county, 3 months next prior, as the law states, to the county in which you respond to. After 7 long years, frustration of my visitation, illegal pendant light child support orders, and an illegal custody decision where my ex-wife committed felony perjury on the witness stand after 3 years of custody battles where Judge Zelkanner walked off the bench where she had been pushing these allegations. She suddenly switched her story in violation of Evidence Code 621 through 623, California Evidence Code. The judge knew that there were false allegations filed. He knew that there was a false police report filed. He knew that there was a false district attorney's complaint filed, and allowed her to commit felony perjury on the witness stand. 17 and a half years later, after that proceeding where he allowed her to have custody after absconding with the children, $10,000 worth of community property, the car, and gutted the house with furniture, I proceeded to set a order aside in the Sonoma County Superior Court. I was denied a hearing. I filed an appeal, which went to the San Francisco Appellate Court, District 1, Division 3. After nearly 16 months of fighting the State Attorney General, there were 5 of them. I represented myself in pro per. I was denied my appeal, although the court acknowledged that my due process was violated by a commissioner by the name of Louise Bales Fightmaster, who sits in the court as a temporary judge under federal incentive programs. Now, it should be noted that the state and the counties receive federal incentive programs for the enforcement of child support. Child support is considered either non-Title 4D or Title 4D. Title 4D is welfare monies. In other words, if money is expended to the child through the conduit of the mother, as noticed in the marriage of Comer, the opinion was written by Chief Justice Ronald George in the late 90s, then the state has a right under federal law to collect the monies that were expended to the child through the mother or through the custodial parent from the non-custodial parent. However, if there was fraud involved in the application process of getting those federal funds, such as Title 4A, which concerns a teenage pregnant mother, or where a father has abandoned the home, or a paternity suit, there has to be the requirement that the party qualify for those monies through the state. California does not recognize whether it's Title 4D or Title 4A or non-welfare cases. In an opinion that was written in 1976 by Evel Younger, former state attorney general,